Hello, everyone. My name is Jessica Nelson, and I'm an associate historian for the Joseph Smith Papers of the Church History Department, and it is my pleasure to welcome you to this afternoon's session of the Church History Symposium. The theme of our session today is Voting Rights Denied, Polygamy and the Idaho Test Oath. At the start of this session, I will introduce our speakers in the order in which they will present their papers. John C. Thomas has been a faculty member in the Department of Religious Education at BYU, Idaho for over 20 years. In addition to teaching, he has published research about Latter-day Saint history in BYU Studies, the Journal of Mormon History, the Religious Educator, and other venues. His graduate training and early career were in international relations and political science. With colleagues from other disciplines at BYU, Idaho, he developed and continues to teach a general education course on religious freedom. He and his wife, Maria, are the parents of 3 adult children.
Thank you. Happy to be on a panel that seems like we're going to give you 3 good slices at an important question. I'll begin by sharing with you some of the terms of the Idaho Test Oath while you think about the purposes that may lie behind this particular method for crowd control. Harvey Smith, when he defended this law before the Supreme Court, described it as a law enacted to discourage the practice of crime. His friend and ally, Fred Du Bois, described it a little bit more politically. It was to end the time when John Taylor and his lieutenants would smother the independence of men's individual actions with impunity. For Du Bois, it was a law about orthodox politics. For Smith, at least before the court, it was a law about crime. When Governor Bunn of the territory signed the law, according to Du Bois, he commended the legislators for their wisdom and broad Americanism. Nonetheless, this law created some problems for Latter-day Saints, one of whom is Samuel Dear Davis. Here in 1887, he's pictured with his wife Mary Jane and their children. In 1888, he, with 16 other Latter-day Saints from the 17 Latter-day Saints from the Samaria ward, resigned their membership in the church in an effort to register and vote. 5 months after the election, they, with another group of men from 2 neighboring wards, were indicted for the crime of conspiracy. Between indictment and trial, Davis had the good or bad fortune to be called as a counselor to the bishop in the Samaria ward, and he was the only man convicted under these charges in September of 1889. That conviction led to a writ of habeas corpus. On denial of the writ, the court went directly to the Supreme Court for what would be the 3rd attempt at constitutional review of the law's validity. My focus is going to be on the arguments put forward on both sides, but especially those on behalf of Davis and the church, and how they failed and yet have had staying power in the years since. This is the team that would be representing Samuel Davis. Franklin Richards, the son of an apostle, young but already experienced lawyer, arguing with some success and failure cases before the Supreme Court, was joined by 2 D.C. veterans, both former congressmen who were helping the church on this brief. Jeremiah Wilson would join Richards before the court at oral argument. Representing Idaho was a 32-year-old Kentucky transplant, also the author of the law, who would represent the state before the bar. This 32-year-old man, Harvey Walker Smith, won 9-0, a unanimous decision from the Supreme Court. How that happened, I hope to explain. I want to suggest it has less to do with his lawyer abilities than with the standard of review the court adopted for reviewing the arguments. Looking back, Du Bois said that Wilson made the others look like pygmies, and he wasn't downgrading their skills. He just thought Idaho won with a slam dunk. But as you'll see from the briefs prepared by each side, there was more going on than a simple oral argument. I draw your attention to the length of the brief for the appellant, for Davis's side, more than 2.5 times the length of that for Idaho. This doesn't just mean they were verbose. It meant that they were fighting a battle. They already knew the court had approved many measures to reduce and eradicate the crime of polygamy, and the burden of proof was heavy. on the side of Davis and the church to show that the territorial legislature had not acted unreasonably when it decided to disfranchise a whole class of people in the name of monogamy. I'll show you briefly what the partisans thought of the arguments. This Tribune was confident that Smith would win. The Deseret News thought Richards did a very fine job. It really doesn't matter what they thought. What matters is what the court decides. These are the challenges that the counsel for Davis would put forward: a First Amendment challenge, a 14th Amendment challenge, and a unique challenge suggesting that Article 6 of the Constitution was also violated by the letter, if not the spirit, of the law. I'll remind you of the wording of those relevant clauses in the Constitution. I'll be summarizing briefly each of the sets of arguments, some of the problems they encountered, Idaho's rebuttal, and then try to take you closer to our day. So on the First Amendment, the great constraint upon Davis's team was the precedent the court had already created. Reynolds was the key First Amendment interpretation in play. Reynolds was a case declaring it completely lawful for Congress to criminalize polygamy. And the great contention before the court was if being a member, joining a church, should also be subject to civil liabilities. Within the constraints of Reynolds, the counsel pointed out that the court had not simply said you can believe anything you want, but once you act, you'll be regulated. The court had actually used Jefferson. Somewhat dubiously, they'd used Jefferson as a First Amendment authority, and Jefferson's statute, his Virginia statute, had reminded government that they should act only when there are overt acts that break out against peace and good order. So Richards and his colleagues pursued the line that church membership did not seem to fit that definition. It had certainly never been criminalized. They also quoted the whole Virginia statute to emphasize Jefferson's point that civil rights have no dependence on religious opinions, and that religion, not just Protestant Christianity, stood equal before the law. They also quoted a lot of founders, a lot of scholars, and a lot of state constitutions, all to make up for the fact they didn't have much on their side when it came to actual case law. One thing they wanted to do, besides making the point that no one had yet specifically criminalized membership in a church, even a church that taught things that had been regulated, was that Congress had done things against polygamy that Idaho transcended. Idaho went further than Congress. The 1882 Edmunds Act specifically prevented registration officials, election officials from discounting the votes of those who had favorable views toward polygamy. As long as they did not commit the crime of polygamy or unlawful cohabitation, they were eligible to register to vote and have their votes counted. The 1887 law said a little bit more. It had a specific oath in Section 24 that those who vote may not directly or indirectly aid or abet, counsel, or advise any other person to commit the crimes of polygamy or unlawful cohabitation. From the point of view of Idaho, they were simply enacting that policy, but counsel for Davis tried to show there was a difference. In fact, they quoted an exchange between Senators Hoare and Edmunds in regard to the 1887 Act. When Senator Hoare asked if Edmunds intended to disfranchise all members of the church, Edmunds frankly replied, "No, I do come out and say frankly, I am not in favor of anything of the kind." And yet it was, for 27 pages of argument about the First Amendment, an uphill climb. The appeal based on the 14th Amendment in some ways anticipates developments in the law more fully. Here, counsel wanted to show that Idaho's act had created a suspect class, in essence. They had created discrimination against a certain class of citizens And though the 14th Amendment had been inspired by the fight against racial discrimination, they argued that religious groups should also be protected by its promises of due process and equal protection. If it was a fundamental principle of government and liberty, then that implied that religious claims should be considered, and here they actually did have some case law on their side. Previous decisions of the court had extended protection beyond Black Americans to whites, at least in theory, Irish Americans, and specifically that year to Chinese residents who had been impacted by the administration of what seemed to be a neutral law. The core idea here was that if you had been franchised, you could not be deprived of it without the due process of law. And they even went so far as to cite a case that would be used by the other side regarding Virginia Minor, a Missouri woman who had tried to register to vote back in the 70s because she was a citizen. Unfortunately for her and for them, the court had specifically said, no, you may not. Citizenship did not equate to a right to the franchise. But as they made this 14th Amendment claim, they wanted to emphasize how far-reaching the language of that amendment was, and that it had implications for the way we read other core protections of the Constitution. This report from the Salt Lake Herald just emphasized this deep equality claim being put forth by Richard. Surely it is unlawful discrimination that a person takes the sacrament or is baptized and thereby loses the right to office or voting. Their most novel claim against the law was that it violated Article 6 of the original Constitution. Here, the specific language wasn't so much the key as the principle that all consideration of religion should be excluded in fixing the political rights of citizens, in some ways an echo of their 14th Amendment argument. They spoke of the anomaly of being able to run for the highest office in the land, yet not able to vote in the same election. And they made the point that Idaho's law seemed to be written in such a way to exclude one particular membership, one particular organization, the one that taught the doctrinal right of celestial marriage, if you know which one that is. So it was in some ways a way to leverage their claims under the 14th and First Amendments about the need for equal protection of religious groups under the demands of those amendments. Ready and waiting was Harvey Smith with his response. An unusual situation to have a 32-year-old lawyer defending a law he wrote before the highest court of the land, but that's what he did, and he did it well enough. The core of his argument was that the right to vote simply was not protected by the 14th Amendment. It was not equated with the rights of citizenship, with the privileges and immunities. In connection to the First Amendment, he had the comfort, or I should say on the 14th, he had the comfort of a recent Supreme Court decision, Murphy v. Ramsey, which had specifically allowed the exclusions made by the 1882 Act, and, unfortunately for the church, had also said legislatures have wide discretion in setting qualifications for the vote. For example, it could be limited simply to married men. He used that, by the way, to say if you were a Catholic clergy and could not vote, or you were a Shaker and could not vote, you surely wouldn't win a First Amendment claim because it happened to exclude you on religious grounds. He also was comfortable citing anti-Chinese statutes to say if Chinese were Confucians and they were barred from political participation, surely wouldn't expect them to win a First Amendment or 14th Amendment argument. Most of the First Amendment argument was met simply by invoking what Reynolds had said. Polygamy is a crime duly regulated by the law. If you belong to an organization that teaches and practices polygamy, you are at least in some ways implicated in a criminal class, not a religious class. And therefore, Idaho had simply cleaned up some of the loose ends in regard to congressional policy. It had not violated any constitutional limits. When he was done, I think it was something of a formality, but it was clear that Idaho was vindicated. In his ruling, Justice Stephen Field said there was not any constitutional or legal objection to the terms of Idaho's law. The legislature had exercised legitimate power and had used a reasonable method, reasonable qualifications for those who would vote, including excluding from the vote those whose advocacy essentially might protect crime or the laws that criminalized it by defeating those laws. Most of the arguments put forth by Richards and colleagues, I would say, were simply ignored. At times, the court simply quoted case law and arguments put forth by Harvey Smith. So what changed since then? The court slowly would adopt its role as a protector of minority rights, and that began with a case about milk, which really has nothing to do with what we're doing here, except that in a famous footnote, Justice Stone suggested that there were times when the court would not be deferential to legislative authority. If a discrete and insular minority, or if liberties in the Bill of Rights were impacted by the law, government should expect more exacting judicial scrutiny or searching judicial review. That very year, this famous footnote was put into effect when members of communist organizations found relief for the first time. The court reversed itself, asserting that membership in an organization that either advocated or even had members practicing crime would not automatically expose you to the penalties of the law. In coming decades, that far-reaching 14th Amendment would come to protect religious minorities, sexual minorities, racial minorities, and even racist minorities from the penalties and sanctions of the law. If we had time, it would be fun to talk about each of those cases, but I will just highlight crucial moments in the 1940s when Jehovah's Witnesses won relief from general laws by showing the burden that those placed upon their religious practice, followed in 1963 by relief for an Adventist woman who, as the court said, had been placed in a position where she must choose between following the precepts of her religion and forfeiting benefits. As Professor Gordon mentioned yesterday, this is an important moment. That decision was announced the same day as a decision that ended Bible study to start the day in Pennsylvania schools. Some people were outraged that this court could do such a thing, but the court in both cases, the free exercise and establishment case, was responding to the needs of minorities burdened by laws made without them being in mind. That trend continued into the 80s before hitting a serious bump, even a reversal in 1990 in Employment Division versus Smith. Here, two men who'd lost their jobs for the sacramental use of peyote sought relief from the government, specifically unemployment benefits like Adele Sherbert had in the 1960s. To the surprise of many, Justice Scalia said that was a luxury the court could not afford to impose. He, with four other justices, rolled back the expectation that strict scrutiny, the compelling interest test, would be used when neutral laws of general applicability burden religious exercise. He encouraged religious minorities to petition for relief and accommodation at the political branches, which is not the most reassuring suggestion. However, as bad as it might look, to have a law that basically now has removed special protection or just constitutional protection for First Amendment complaints, as Smith has been applied, it actually led to the official demise of the court's reasoning about the Idaho law. 3 years later, Santorians who wanted to perform animal sacrifice found themselves essentially hedged out of a city by the ordinances in place. As the court reviewed their complaint, it found that this was not a neutral law of general applicability, and therefore the government must show interests of the highest order were being met by means very narrowly tailored to accomplish their purposes. Just as Anthony Kennedy said, they manifestly failed to do so, and in fact the law showed evidence of hostility, although it was covert. Importantly, in this unanimous decision, the author of Smith, Justice Antonin Scalia, reminded us where he stood. He was confident that such a law that singles out religious practice for special burdens, could not be characterized as neutral. And though he was less confident than Justice Kennedy that one could track down judicial hostility, he was sure that not being neutral was enough to be a problem. 3 years after that, a gay rights case, one of the first important gay rights cases, led to a specific reversal on Davis versus Beeson. A Colorado amendment had made it essentially impossible for lesbians and gays to get relief from non-discrimination statutes, and the court found that law wanting on many 14th Amendment grounds. Justice Scalia dissented. His dissent obliged the court to say specifically about what was wrong with Idaho, because Scalia had said Idaho did something much worse, and we unanimously approved it 100 years ago. These were the two key flaws in Idaho's law, according to the court in 1996. Advocacy should not be the basis for exclusion from the vote, and the action and status distinction, which Harvey Smith had blurred, which his law had blurred, and which the court had blurred, was not enough was actually suspect and would be subject to strict scrutiny and most likely fail. As I conclude, I just want to talk about the death of Harvey Smith and the birth of his law and think about what it means. This young man, at 35, was appointed to Utah's Territorial Supreme Court, having successfully defended Idaho's statute before the Supreme Court, having defended Idaho's Constitution, which adopted the statute before the United States Congress. He then continued his winning streak as an associate justice in Utah, then died in office at the tender age of 38. At his passing, his success in defending the law was respectfully noted. 35 years later, part of the birth of the law was revealed for the first time in what the Idaho Statesman called the most dramatic incident in Idaho's history. As I conclude, I'd just like to draw your attention to two things. I'm not sure the gun would have made that much difference in the way the Supreme Court reviewed the Idaho law in 1889. Cole Durham has said the central drama in religious freedom is about something kind of boring, the standards of review. But the standards of review make a great difference. And though Idaho's former Attorney General thought perhaps publicity about the means by which the bill became a law could have affected its validity, it's all about the burden of proof. In 1889, a very deferential Supreme Court assumed that the territory, like the nation, had good reasons for eradicating a crime, though often they failed to distinguish between the crime and the church, between the practice and the people. But once that law was subjected to stricter scrutiny, it was going to be dead. Thank you.
All right, so we have about 10 minutes for questions. These mics here in the aisle should be on, so you should be able to come here and state your question. Thank you.
My question might be for Hannah or someone else. That I was doing my family history and in South Dakota, and I came across naturalization documents for someone, and there's a line in there that says, "Are you a polygamist or practice polygamy or whatever?" Do you know the history or anything about how that ended up in the naturalization documents anywhere in the country? I don't know if you could answer that question.
Just to add to that, and I agree Jeff Turner's probably the authority, but as soon as the 1879 case is decided, the executive as well as Congress begins to actually blur the distinction. And in 1879, in a cabinet meeting, Secretary of State Everett said, we actually need to issue a memo around the world, suggesting that the need to tap down Latter-day Saint missionary work and immigration from other countries in the interest of enforcing the anti-polygamy laws. And so from 1879 through the next few decades, really, there is this sense where the law actually doesn't maintain Waite's framework, not just discretion of individuals, but things enacted in statute, in formal policy, executive orders, basically begin throughout. It isn't actually in the interest of the government to make a nice distinction. Having poor distinctions maintains pressure on the church to get compliance.
So I have a couple of related questions. One, just coming at the whole belief-action distinction, which can't be the real definition of religious freedom. It's just because if you would then maybe have freedom, you could still have freedom in the gulag. I'm sorry, I can't stop my watch from ringing. But interesting, in international law, what you typically see is people talking about the distinction between forum internum and forum externum. And one of my questions is just as people write about this and talk about this, and as we've talked about it today, no one has mentioned that. I wonder if that distinction is something that crops up explicitly in the cases like the Idaho cases that you're talking about. Then the other part of this is, it's really more directed at Hannah. I mean, obviously, it seems like you're saying, gee, if we look at these cases, it's hard to tell action apart from mere thoughts. And this is true all over the law. I mean, we have mens rea requirements, we have all kinds of mental requirements, and since we don't have access to other minds, these are always dealt with by behavioral standards. But it almost seemed to me like you were saying, well, look, we have to, this is a messy distinction, and so the law takes mere thought into account all the time. I think it's a really important legal point that it doesn't take that, and this was a mistake, a constitutional mistake in those cases. I mean, and that we've got beyond that, which is very significant. And I just, where do you stand on that issue? Do you think it would be a good thing to blur this distinction, or should we really have something like the forum internum, forum externum distinction and abide by that very carefully?
Well, you know the international law better than we do, but I'll just say this. Richards makes the case before the court that belief is absolutely free. The inner forum cannot be constrained in any way, but he is explicitly, they spend a lot of time, and so did other advocates in the Idaho cases, to say it is not simply belief versus conduct. Lots of conduct is protected. Membership in a church has never been criminalized. If it's never been criminalized, how can it be an overt act against the peace and good order, which again is not constitutional language, it's Virginia statute language, but they made that case again and again, and it's not really until the 20th century that you begin the court using new verbs, right? Burdened, impeded, a costly trade-off, talking about external behavior, right? Conduct religiously inspired, which is being met by some sort of civil penalty. To try to have a fairer distinction than this initial one. So when I see Reynolds glossed, as it is in the things my students read, as a belief-action distinction, it's perfectly useless. Because as you've said, you'll be free in the gulag to believe all you want. You have to have some line drawn, and of course what the court does is it says, let's make the case for why polygamy is beyond the line of overt acts that threaten peace and good order, and the case they make for why it's such an act is racist, it's xenophobic, it's Christian, it's a poor case. It wouldn't be used today. The arguments used to show why polygamy met that standard would not work today. So it's good to begin with the distinction, but that's not even where they drew the line, and how they drew the line is subject to, criticism.
I just have some, I'm curious about how the Davis versus Beeson is argued, right? Because it's interesting in the polygamy cases, because they're invoking the 14th Amendment. And I am wondering do the civil rights cases or the slaughterhouse cases, which had recently been decided, are they showing up in the arguments over the scope of the 14th Amendment, and how are those being used or interpreted?
Short answer is yes. The brief for the church for Davis cites them. It also cites Cruikshank. It cites Yickwo v. Hopkin. It cites things that give hope that the 14th Amendment is not just about barring racial discrimination. But nothing happens with those citations. So we've got to national origin by 1889. Nothing else will happen until the 30s, 40s, 50s, 60s. It's not till the 60s that the Supreme Court agrees that the vote is a fundamental right where restrictions, lots of restrictions could be subject to strict scrutiny. So they really are ahead of their time when it comes to 14th Amendment. The difference is they at least have a little case law to buttress their argument, unlike the First Amendment.
All right, so we've reached the end of our time here. I want to thank all of our panelists again. Please join me in applauding their efforts today. And yeah, thank you again for coming.